The organizers of this conference have asked me to reflect on the final text of the new forthcoming directive on representative actions for consumers, and to reflect about that new instrument. Now, before I will start doing that, I will have a little introduction very briefly, because I assume that most of the people who are listening to this presentation know what the background is. For a number of years, European member states, European jurisdictions have been confronted with a number of mass cases. And on the slide, you can see some examples: the Volkswagen case, the PIP breast implant case, delayed planes, the Fortis case. And a lot of these cases, some of these cases occurred in specific member states, but also other cases. For example, the Volkswagen case has occurred in many member states. And then we have seen over the course of the years many individual and collective proceedings in those individual member states, sometimes coordinated. For example, in the Volkswagen case, some of these actions were coordinated. In other cases, this was not the case. So this remains, this was a big problem in the last couple of years. Now, also for many, many years, the European policymakers have been aware of that problem, and a lot of initiatives were taken to tackle that problem. And on the slide, you can see a number of reports and green papers and consultation papers and white papers and whatever that deal with that collective redress problem, and that basically all come down to the same thing, the same conclusion, in the sense that we need a vehicle to tackle those problems, because what we have now, what the individual member states have now, is insufficient. So they need collective redress tools on the one hand, but also on the other hand, we need something to coordinate and to resolve the fact that a lot of these mass cases happen in many jurisdictions. We need an instrument to make that easier. In 2013, the European Commission issued a recommendation, which is a non-binding instrument, on common principles for injunctive and compensatory collective redress mechanisms in the member states concerning violations of rights granted under union law. And in that recommendation, the European Commission issued some principles that member states should take into account when crafting, when developing, when writing collective redress instruments, collective redress acts. The recommendation focuses on injunctive and compensatory collective redress. This will be important for what I will say in a second. The scope is basically universal, transubstantive, it is called in class action law, or sectorial in a specific sector, for example, consumers. Standing should be given to ideological plaintiffs, what Rachel Mulliron once called the associations, organizations, special purpose vehicles, public bodies. The default should be opt-in, but more and more opt-out is also being allowed, and the focus is on collective settlement. So this was basically just, an overview of some general principles that member states should take into account. In 2018, the recommendation was evaluated, and the conclusion of that report was not very good. Basically, the report concluded that many member states continued to do whatever they wanted to do, and they didn't really take into account what was in the recommendation. In some cases they did, but okay, the ultimate conclusion was that the recommendation did not have such a big impact in what was going on in the different member states. In 2018, the European Commission launched its new deal, and I assume that during this conference this morning and also yesterday, this was probably mentioned quite a lot. And one aspect of that new deal of 2018 deals with that collective redress problem. And the European Commission made a proposal And that proposal then went to the whole legislative process, and I will not talk about that because that will take us too long. And then on the 22nd of June 2020, of course, this is not Brussels. You can see that this is the Vatican City, but I think it's a very nice image. In June 2020, the European Council and the Parliament, they reached an agreement on that new instrument. And the structure or the idea of that instrument is basically not very difficult. What they are doing, and I will explain that in a second, they are using an existing instrument and they are adding another layer. Now, of course, as you can see on the slide, perfection is not of this world. It's, of course, a very controversial issue. Collective redress has been controversial for many, many years. And that new directive, that will be exactly the same. And there are some who are saying, okay, it's not a perfect instrument. It's not something that will change the world, but at least it is something, it's better than nothing. On the other hand, other voices say, okay, this is terrible, this will not work. Why are we putting our time and our effort in this new directive if we will not think that this will work? So it's somewhere a balance. I personally, that is my personal opinion, I think it is good that there is an instrument because at least now there is a more solid, and you can debate about that framework, but at least there is now a solid framework that will probably steer the debate in the coming years. Much more, I think, than the recommendation, which was non-binding, but now this directive will be binding. And the idea is, and I'm going a little bit too quickly, I think I forgot, yeah, this one, it's here. And the idea is basically at the outset, the European legislature is taking the injunctions directive. Everybody knows the injunctions directive, qualified entities, bodies, they can bring proceedings in the member states and they can ask for injunctive relief. What the new instrument basically is they take basically the same structure, but they are adding another layer in the sense that these qualified entities, these qualified bodies, they can in the future not only bring proceedings for injunctive relief, but also for compensatory relief. And this instrument is called the Representative Actions for the Protection of the Collective Interests of Consumers. I have seen in some blogs and in some publications, it's called the RAT, the Representative Actions Directive with a D, not with a T. It's not a rat, but the RAT. And the references in my presentation go back to the version of the 26th of June, because there were some other versions and the articles changed a little, the number of the articles changed a little bit. But to be clear, the references in my presentation are that version. And in the forthcoming weeks, the new directive will be published, and then the member states will have 2 years to implement the directive. And in some countries, that process is already being shaped. For example, in Belgium, we now have a new government in Belgium. I know that they are already working or doing some preparatory works for the implementation of the directive. Now, I would like to talk about 2 things. First of all, I would like to sketch a little bit the bigger picture, because one of the deficiencies in that whole collective redress debate, according to me, but that is my humble opinion, is that sometimes people are a little bit too much in thinking and working in their own little boxes, while there are other boxes that are not boxes that compete with your own box, but that could work very well together. I will explain myself later. The second part of my presentation, I will focus, if the time allows me to, I will focus on some specific aspects of the new Representative Actions Directive. I will not go into the details because I don't think that is the goal of this presentation, but I have 4 remarks, general remarks, that I would like to make about the instrument itself. First of all, It's not a secret that in many member states there are already collective redress instruments. They look very differently. The landscape is very scattered. But if you look at what is going on in all of the different jurisdictions, then there is one general conclusion that one can make. And that is that the number of cases that are being brought to date are very limited. For example, if you look at Belgium, Belgium implemented, and you can see on the slide an overview of the 9 cases that were brought. I think I only have 8, I forgot one. The 9 cases, 8 cases that were brought in Belgium by Testaccia, Belgium's biggest consumer association that is quite active in this field. They have brought, since 2014, the act entered into force the 1st of September 2014, they have brought 8 cases. And some of these cases were partially settled, which is a good thing, but other cases are still pending. Also, in other countries, the number of cases, for example, Scandinavia, that has group actions since the 90s. Also, when you look at the data there, and a number of years ago, in 2017-18, we tried to collect as much as data as possible, then you see that the number of cases is fairly limited. And then the question arises, why is that? And a couple of years ago, we did a study, and then we went to those countries. We spoke to consumer associations, we spoke to legislators, and we were asking, okay, you have this instrument, but why are you not bringing these cases? And then the answer was always, okay, it's a very good thing, but there are other alternatives. And what you then see is that in a number of cases, a lot of these mass cases don't go through the judicial carousel. They are being settled by other instruments. And one of these instruments is consumer ADR, which also came to the fore in 2013, I think, with the new ADR directive and the ODR regulation. And if you look at a lot of these countries, then a lot of these mass cases are being resolved via ADR mechanisms. Now, if you look in the Representative Actions Directive, and as you all know, again, this is not a secret, during the debate, you have the traditional debate between the lobbyists of the businesses and the consumer associations, and the lobbyists of the businesses, of course, don't want collective redress mechanisms. They say, okay, ADR, Ombudsman is much, much better than judicial mechanisms. And what you saw, and when you read those reports, it's, of course, it's every time it's the same, but the consensus or the result of that debate was that in the Representative Actions Directive, there's a very strange article that basically deals with the cross-border issue, with cross-border mass actions, or cross-border representative actions, and there the directive states that this might be solved by establishing a European Ombudsman for collective redress. When I read that, I was a little bit, I don't know. It was not very clear to me also when you look at the preparatory works what they mean with that, and whether this will actually be the right mechanism, the right institution to resolve these issues. The Representative Actions Directive also pays attention to resolving mass cases out of court. A lot of attention in Article 8 is paid or to settlements on redress. And what you can read there is basically the same what you could find in the 2013 recommendation, and also what you find in a number of European countries. For example, the Netherlands. The Netherlands has a system basically that is based on collective settlements, although they supplemented it last year with a real class action mechanism. And the Representative Actions Directive states that the qualified entity, which is the representative and the trader, may propose a collective settlement. And that is a good thing in the sense that the court should not blindly homologate, approve that settlement. No, because that settlement, of course, deals and adjudicates the rights of people who are not there, absentee consumers. The court should scrutinize, of course, that collective settlement. Whether in reality that happens, for example, some studies have been done, for example, in the Netherlands, is a question. In the Netherlands, I mean, that is being done, but some aspects of that, for example, regarding the costs and the fees, is still very, very delicate. But I think that is a good thing that can be found in the Representative Actions Directive. A second aspect, and that's a second tool that sometimes is being used and is also quite controversial, but is gaining more and more attention, is the question whether public enforcement regulators should be involved in resolving mass cases. There is a little bit of legislation, I will come back to that in a second, but again, when you, and our empirical research showed that, when you go to a number of these countries and you speak to some institutions, then basically what they are doing is what is called regulatory redress. Normally a regulator, when a regulator finds out that the company does something wrong, they hit the company with a fine. The fine usually is capped, but what they are not doing is they are not paying attention to the harm, the damages that consumers, shareholders, other people have suffered. And there it's up to the shareholders, consumers, victims to act individually or collectively. In some member states, this is being done differently. And on the slide, you can see some examples. I will not go into details because I don't have the time. For example, the Banca d'Italia, which is the financial regulator in Italy, for example, can issue what is called specifiche forme d'offerta, which is basically an order that they send out to the banks, and they are saying, okay, you did something wrong, you have to pay back everybody. Okay, and if you will not do that, we will give you a bigger fine. Scandinavia is another example. The Danish consumer ombudsman, who is not really an ombudsman but a regulator, also has tools to compel, to force companies into a sort of settlement or paying back consumers. That debate was done, for example, and the background, and I think this is important, the background of that is the fact that public enforcement does that, I mean, there's not a clear division anymore. Walter van Herven, a colleague from the KU Leuven, who used to be an advocate general at the European Court of Justice, European Court of Justice, said we should not strive to the division between public enforcement and private enforcement. We should strive to what he called a multi-layered framework of regulation, lawmaking, and law application. And I think that is the background of a lot of these evolutions. For example, ADR and regulatory redress, it is not the consequence of a well-targeted policy. No, it's something that was developed by the market because the judicial system was insufficient. It was not possible to bring collective actions, or it took too long, or it costs too much money, or it's too uncertain. So then the market started to create these own mechanisms. In the CPC regulation, you can find that a little bit during the debate with as a consequence, the new CPC regulation of 2017, that debate was done regarding regulatory redress. And in Article 9, you can see the result of that, which is very, very light, which is very, very soft, in the sense that competent authorities can have one of the following enforcement powers: the power to receive from the trader on the trader's initiative, not on the initiative of the competent authority, additional remedial commitments for the benefit of consumers that have been affected by the alleged infringement covered by this regulation. And some have said that this is a little bit of a missed opportunity. Another thing, and this is, I think, a good thing, that also can be found in the Representative Actions Directive. I will come back to that in a second regarding the qualified entities. Member states may designate public bodies as qualified entities for the purpose of bringing representative actions. And you can see that already in some countries. For example, in Belgium, class actions can be brought by consumer associations, but also by the Consumer Mediation Service, which is the residual ADR entity. And they have already brought one case, and there is now currently an evaluation pending at the ministry, and the idea is being explored whether they should expand that possibility to bring a class action not only by consumer mediation service, but by all ADR entities that form that consumer mediation service. So that is an example of that interference between public and private enforcement. And I'm not going to say, and I know again this is quite controversial, I am not going to say what is better. Okay, what I really think, what I really believe in, is I think that these things should work together. And there are quite a lot of examples. There's a lot of experimentation going on. For example, giving standing to ADR entities, giving standing to public bodies. In the Netherlands, since 2012, there is an act on prejudicial questions. There is now a debate there whether, for example, when an ADR entity is being confronted with a collective problem, whether they should have the possibility, when there is an issue of law, because issues of law should be decided by the courts, whether the ADR entity should be able to ask, for example, a prejudicial question to the court. And the court answer that question, and in the light of the answer of that question, they can resolve the mass case out of court. So there's a lot of experimentation going on, but what I really am missing in that whole debate is basically the interconnection, the interaction between these different mechanisms. And the problem is that a lot of these policymakers, they are thinking only in their own box, and they are not looking outside of their box. And if they would speak, for example, more to each other, if they would see what the other one is doing, then I think that could be beneficial for everyone, and ultimately for consumers who are the victim of these mass cases. Secondly, I want to mention 4 things about the Representative Actions Directive itself. First of all, the scope. Article 2.1 states that the directive shall apply to representative actions brought against infringements by traders of provisions of the Union listed in Annex 1, and also as transposed into national law that harm or may harm the collective interests of consumers. So the Representative Actions Directive focuses on consumers. The question then arises whether this is not a discrimination, because now you have collective access to justice for consumers, but for non-consumers, you do not have collective access for them. They have to sue individually, or they have to work with a mandate, etc. The same problem arose in Belgium in 2014. We had exactly the same system. It was only for consumers, and there was also a list in the act that basically were only provisions for consumers. The question was submitted to the Constitutional Court whether this is not a discrimination, and the Constitutional Court, so what? It's not a problem. The reasoning of the Constitutional Court I never understood. They said no, because most of these mass cases are consumer cases, so it's not a problem. I mean, I was absolutely not convinced about that. In France, the Conseil Constitutionnel, which is more limited, also issued something in the same lines. But I really think that this is actually quite problematic. Besides the practical problem that every time when there is a new legislation or existing legislation will be amended, then they will have to amend that annex. 2, at the core, at the center of the whole mechanism are qualified entities, organizations or public bodies representing consumer interests, which have been designated by member state in accordance, qualified in accordance with this directive to bring representative actions. And a distinction is being made between domestic and cross-border actions. And this is something that I think is quite problematic. When you look at the first proposals, that distinction was not made. But during I think the Croatian presidency, I don't know, that really became this key problem. So the mindset, the structure of that whole directive shifted to that problem, and they really wanted to resolve the issue of cross-border mass cases. And they made a distinction between domestic representative actions and cross-border representative action. And a domestic representative action is an action that is brought by a qualified entity in a member state in which the qualified entity is designated, and a cross-border action is an action brought by a qualified entity in a member state other than in which the qualified entity is designated. For example, Testachat, Belgian qualified entity that is bringing a case in France or that is bringing a case in the Netherlands. Okay, that I can get. But then the criteria for the qualified entities to bring these cases differ. And that I think is quite problematic. Regarding cross-border representative actions, qualified entities should meet a number of requirements that are set out in Article 4.3 of the Representative Actions Directive. They have to have legal personality, they need to have 12 months of actual public activity in the protection of consumer interests, they have to have a non-profit making character, they have to be independent, they have to disclose a number of obligations. So there are a number of quality requirements that qualified entities have to meet in order to bring a cross-border representative action, which is a good thing because it is coherent, it's certain. But when you have a qualified entity that wants to bring a domestic representative action, they don't have to meet those criteria. Then it's up to the laws of the individual member states to set out the criteria. And the only thing the directive states is that the criteria have to be in light with, or have to be consistent with the objectives of this directive. But member states can apply the criteria for qualified entities bringing cross-border representative actions also to qualified entities bringing domestic actions, but they are not obliged to do so. I don't think this is a very wise decision because then the quality criteria for domestic representative actions could be lower than the quality criteria for a cross-border representative action. And I don't really see the goal, the ratio legis behind that difference. So I don't really think also in practice how this will work, but I do think that this is a problem because it can create basically an imbalance between qualified entities that want to bring cross-border representative actions for who the standards are higher than qualified entities that only bring domestic representative actions for whom the criteria can be, I'm not going to say it will be, but can be lower. Third issue, you can have a whole conference about that, is the application of international private law. Okay, this was also something that was discussed quite a lot. Basically, the Representative Action Directive says, just apply the Brussels 1bis regulation, Rome 1, Rome 2, poof, period, finito. No specific provisions. The Article 2.3 also states that, which I don't really get because the shifting of the mindset of the instrument was we need to have something to tackle cross-border mass cases. And they make a distinction between domestic and cross-border representative actions. But then on the other hand, they say, well, regarding jurisdiction and applicable law, the existing instruments apply, which is absolutely not the case. And the problem then is that the Court of Justice of the European Union, on the one hand, and I refer to the opinion of Attorney General Bobek in the Schrems case, who basically said that the Brussels 1bis regulation and collective redress, it's very complicated, it's complex, and it cannot be solved, and I think he's absolutely right, on the basis of an instrument that is unfit and that is in the need of comprehensive legislation. And they did that debate when they revised the Brussels 1 regulation. Unfortunately, a consensus could not be reached, so they did not have a solution for that. So on the one hand, an attorney general says, okay, you cannot work with that instrument, but on the other hand, the court, of course, has to deal with the things, or has to, adjudicate the cases that come before them. And they have to do with the Brussels 1bis regulation they have to do it with that Brussels 1 bis regulation. And an illustration you can see on the slide, it's a very recent case of July 2020. It was a Volkswagen case in Austria, where the Austrian Consumer Association brought a case, and the question was, where is the place where the damage occurs in the sense of Article 7.2 of the Brussels 1 bis regulation. And there the court said, also again a controversial decision. I have read comments that were not very positive, but I do think that the decision is actually a good decision and is a very logical decision, that the place of damage is the place where the consumer has bought the vehicle and not the place where the damage was basically fabricated in Germany. But there are, what I've heard is there are other more cases that are coming to the fore, but it will be a problem that will have to be resolved at one point, because if in the future more of these cases will be brought, these cross-border representative action cases, which is one of the cornerstones of the Representative Actions Directive, then these jurisdictional problems, of course, will arise from time to time. So that is something that is, I think, a little bit naive of the European legislator. The final point, and then I will stop because I see that the time goes quite quickly, is actually something that is problematic in many countries and is something that I don't really understand, in the sense that in a lot of countries and the European level, it's the same. And that was very striking, for example, in the 2018 implementation report of the 2013 recommendation, where the European Commission said every country should have collective redress mechanisms and they should look like this. But how to fund and to finance that? Oh, we don't know. We will think about that later, which absolutely does not make sense. If you want to create such a vehicle, such an instrument, the first thing you have to do is who will pay for that? Because the problem in collective redress is that the representative is acting on behalf of parties who are not part of the proceedings, so who cannot pre-finance the procedure. So you have what I once called a triangular structure on the side of the plaintiff, which makes it, from the funding perspective, quite complicated. Now, not a lot of attention is being paid to that. In the original proposal, more attention was paid, but ultimately, it was boiled down to one article, Article 7, that deals with third-party funding. So more and more insurance companies, but also other companies, they are funding these proceedings. In some countries, all of the class actions, for example, in Australia, all class actions basically are funded by third-party funders, which is based on a contingency fee. So in the sense that the third-party funder funds the whole proceedings, also the lawyer's fees, also the court costs, but then ultimately when the case is settled or there is a decision, then the third-party funder wants to have a percentage of the money, the damages that is awarded to the class. Usually it's about 30%, 1/3, and which is a very difficult thing, because also from ethical point of view, it's very complicated. And for a number of years, arguments have been made to have a form of what is called soft regulation to deal with that. And the Representative Actions Directive pays attention to that. I don't think very strongly. What they basically did was copying the principles from the 2013 recommendation. And the goal is to prevent conflicts of interest, because if a representative brings a case, then of course the interests of the consumers should be central and not the interests of the third-party funder. For example, when there are negotiations about a collective settlement, then of course you should find a settlement that is in the best interest of the consumers. But if you have at the table or outside or on the phone a third-party funder who is influencing these negotiations and these settlements only in his or her own interests, then of course this is something that should be avoided. And one of the rules is that when a qualified entity is using third-party funding, it should disclose that to the court. Also, that is, you can debate about that. I mean, okay, the fact that you are being funded by a third-party funder, okay, that's one thing, but then should that qualified entity disclose, for example, the agreement it has with the third-party funder to the court, only to the court? I think in some cases, for example, I think in the Netherlands, it's possible that this is only disclosed to the court, but not to the other party. In Belgium, I don't see that happening. If that agreement, that funding agreement should be disclosed, then it should also be given to the other party. And then the question is that fair? I mean, because then one party has to put on the table all his internal, of a large part of its internal information, while the other party does not have to do that. So I think that's something that is not being thought about. Of course, the third-party funding does not divert the action from the protection of the collective interests of consumers. Very fine, completely agree. But how to do that in practice is something else. And also the fact that decisions of a qualified entity cannot be influenced by a third-party funder, which is, I think, a little bit naive. Because if you look at some cases outside of Europe, again, to Australia, then in reality, of course, the qualified entity is listening to these third-party funders. The good thing is the focus in these countries is not so much on regulating what should happen in a procedure. What is done there is you should regulate the third-party funder. You should force the third-party funder to be transparent, to publicize a lot of information, to have an ethical code of conduct, which they, for example, did in the Netherlands. The claim code is basically an instrument that was developed for these institutions, these organizations, these foundations that are involved in these collective redress proceedings, to force them to be transparent, to be open, and things like that. So I think there are still a lot of questions. I always, and some people in the audience probably know the comparison that I always make. I think that class actions, collective redress in Europe are basically a box of chocolates. I'm a Belgian, so we like chocolates. And to quote Forrest Gump, you never know what you're gonna get. Thank you very much.